A contracting party with reasonable grounds to doubt that the other party will perform under the contract can request adequate assurance of performance. What constitutes adequate assurance is the subject of Smargon versus Grand Lodge Partners. Daniel Smargon contracted to buy a condominium unit from Grand Lodge Partners. The condominium development wasn't yet under construction when he signed the contract. After reviewing construction plans, Smargon discovered that his unit would be across the hall from the mechanical room housing climate control equipment for the entire development. Grand Lodge assured Smargon that it would try to minimize any noise or disturbance from the mechanical room in his unit. The day before the scheduled closing, Smargon did a walk-through inspection of the unit. Noise and vibration from the mechanical room across the hall disrupted the inspection. Smargon canceled the closing. In an email to Smargon, Grand Lodge acknowledged that the mechanical room was causing disruption in Smargon's unit. Grand Lodge claimed that the problems during the walkthrough were due to unusual circumstances, but said that normally the sound levels were much lower. Nonetheless, Grand Lodge listed some specific actions it might take to reduce the noise. In a subsequent letter, Grand Lodge asserted that Smargon was now in default. Grand Lodge said that it had mitigated some aspects of the noise and was taking further steps, but gave no specifics. Finally, Grand Lodge told Smargon he could proceed with the closing or be refunded his deposit and the additional amount he'd paid for upgrades to the unit. The letter gave Smargon about a week to accept one of these options. A week later, Grand Lodge wrote to Smargon again, asserting that it had performed its contractual obligations and that Smargon had defaulted. Grand Lodge claimed to have taken measures to reduce the sound from the mechanical room and made significant efforts to resolve Smargon's concerns, but again offered no specifics. Grand Lodge reiterated the offer to refund Smargon's payment or have the closing, demanding Smargon's response the next day. If not, Grand Lodge would unilaterally terminate the contract, keep Smargon's money, and resell the unit. Smargon sued Grand Lodge for breach of contract. Grand Lodge counterclaimed, also alleging breach of contract. The trial court granted summary judgment for Smargon, concluding that Grand Lodge had repudiated the contract by failing to provide adequate assurances that it would perform as required. Grand Lodge appealed to the Utah Court of Appeals.